name is Tamani Taylor, and I co-present with William Schlaerth on the topic of Is Justice Blind and What is a Jury of One's Peers? And we evaluate those questions in the context of jury selection. And so, well, I want to start out as talking about the cases and the law that prohibit the use of a peremptory challenge solely on the basis of race. And the two precedent cases that we're talking about are Kentucky v. Batson, which is a US Supreme Court case, and People v. Wheeler, which is a California Supreme Court case. Now, in order to make a Batson-Wheeler challenge, it's a three-step process. The first step is the prima facie case, where the burden's on the defense to show that the purpose of the challenge was a race-based exclusion. Once that prima facie case is established, then the burden shifts to the prosecution or the other side, the other attorney, to give a race-neutral reason for that challenge. The court then, the third step is the court then evaluates the attorney or the prosecutor's reason and determines whether or not it is indeed race-neutral or if it was race-based. If the Batson-Wheeler challenge is granted, then the juror can be reseated. If that's not possible, then a mistrial can be declared. An attorney may be required to report a ruling to the state bar that they did in fact violate Batson-Wheeler in the exercise of one of their challenges. There is some legislation in front of the governor, AB 3070, that seeks to change some of the requirements of Batson-Wheeler. And the purpose of the legislation is to increase juror diversity. And so we want to take a look at what is the sources of exclusion of people of color traditionally from jury service. And we start kind of with the historical context, starting with slavery. Of course, all civil and civic rights were taken away from slaves. But then we have the Civil War amendments, that's the 13th, 14th, and 15th Amendments, which tried to restore some civic and civil rights. The 13th Amendment specifically prohibited slavery. However, there was an exception as punishment for a crime. And so when the 13th Amendment was passed, Southern states passed what they call the Black Codes for newly freed slaves. And that required them to enter into labor contracts with their former slave owners or else be considered vagrant. And vagrancy was considered a crime. And the punishment for vagrancy was that a former slave would then be leased to their prior slave owner. And so during this period of time, there were statutes on the books in the Southern states that restricted jury service to whites only. The Supreme Court came out with Schlaerth v. West, and that case held that statutes that restricted jury services to whites was unconstitutional. However, shortly thereafter, Plessy versus Ferguson was upheld in the Supreme Court, which allowed for separate but equal. And therefore it kind of supported the exclusion of people of color, specifically African Americans, based on a practice. So what it would do is they were allowed to have vague qualifications for jury service, such as morality tests, intelligence. And so there was a practice of excluding people of color, specifically African Americans, from jury service. The court then came out with Norris v. Alabama and held that you can exclude people of color even through the process, through your practice and process of qualifying jurors. That is a constitutional violation. It violates the 14th Amendment. However, they then later on came out with the Atkins, Texas holding, in which they said you can limit the number of people of color. And in that case, the jury commissioners testified that they intentionally only allowed one African American on the grand jury. Supreme Court said that's okay. So besides just the qualifying for to be a juror, other sources of exclusion have been just being able to prove that a peremptory challenge was based on race. So the Supreme Court came out in Swain and said, hey, look, in order to prove racial discrimination in jury selection, you have to prove that in this particular jurisdiction, no person of color had ever been able to be on any jury ever. California Supreme Court came out shortly thereafter in People v. Wheeler and said, hey, that's a high standard that probably nobody can meet. And so they said, if you can prove it's more likely than not an exercise of a peremptory challenge was based on race, that is enough to shift the burden for us to evaluate whether or not that actually occurred. The Supreme Court came out with Batson a few years later, which overturned Swain and kind of did one better than Wheeler and said, well, we're going to make the standard that it gives rise to an inference of this racial discriminatory use of a challenge. So, beyond qualifying, beyond proving, other sources of exclusion of people of color have been the use of source lists. So currently in most jurisdictions, especially in California, they're using the Registrar of Voter and the Department of Motor Vehicle lists. Those lists already substantially, studies have shown, underrepresent the community at large, but there is a larger underrepresentation of people of color, especially African Americans, when you use those lists. Additionally, even though Batson and Wheeler has done some good things, Batson and Wheeler don't prevent intentional discrimination veiled as race neutral. So an attorney can say, well, I know that people with dreadlocks generally don't trust police. That's a race neutral reason, even though really it's very race based. And so that continues to be a source of exclusion, Batson and Wheeler. Additionally, there's really not a lot of case law that addresses implicit bias in jury selection. And the only kind of analysis that tries to deal with that is really comparative juror analysis. But an attorney's exercise of a peremptory challenge based on unconscious racial bias is very pervasive, meaning it happens all the time. And it's just because of the way our brains are wired. We rely on stereotypes, especially racial stereotypes, where we're under high stress and where we're making decisions based on small bits of information. And nowhere kind of in a trial do I think is that more truer than in jury selection. We have a lot of people we're trying to find out whether or not they're good jurors based on a very small bit of information. And it's usually a high stress because we have hundreds of people looking at us as we're asking questions. So now we kind of move to the question of what is a jury of one's peers? And the law says, hey, a fair cross-section of the community. I think that's just another way of saying diversity. But does diversity matter? Does it impact jury deliberations? Is the impact negative or is it positive? And in examining that, I looked at a 2019 Southern Illinois University study, which found that diversity reduced disparity in the quality of deliberations for Black defendants compared to white defendants. It improved overall deliberation performance. It reduced racial disparity in outcomes. And it increased the discussion of race-related issues germane to the case. So how do we increase? So it has a good effect. It has an effect and it's a positive effect. So how do we increase diversity? We increase and change the types of source lists we use. We can use tax lists, phone directories, benefits lists, things that give us a more well-rounded representation of the community at large. We implement some of the, we implement AB 3070, which gets rid of the prima facie case that the defense has the burden to prove a racial intent. It prohibits stock race-neutral reasons that really aren't race-neutral reasons. He listens to rap, therefore he's more likely not to distrust the legal system. That's a race-based decision that's been decided by courts to be race-neutral, and we just know that's not a fact. Account for implicit bias, more than just comparative, by using comparative juror analysis and other studies and other things that can work. Additional steps you can take now is get the court to rule exclusion of one person of color establishes a prima facie case, especially where there's very few people of color in the entire jury veneer. Request discovery of attorney's practice and pattern of exclusion. Argue that race-neutral reasons given is based on implicit bias of a cognizable group. So big hoop earrings being a sign that they won't be a good juror is an implicit, is a race-based implicit bias that might be that might be a little bit more hidden. So that's basically the presentation, and I've given here some sources that I've used here that you can look at, and I hope you've learned something and that you'll join us for the full presentation. Thank you.